Hello, I'm Robert, a voluntary fact checker and helping you if you're scared of many things. And this is to help to understand this very confusing decision by the Supreme Court on birthright citizenship and on state and universal injunctions. So I'm not a lawyer, I must say that. I say that from the outset. But what I can do is I am quite good at helping to explain complicated things in ways that are easier to understand. And looking at the television and people talking to me and so on, it's confusing people a lot. So either it is hugely oversimplified, or you get these legal professors going into great detail but in such complicated ways it's hard for anyone to understand. So I'm trying to help explain it in a simple way. That's my main point here. So the outcome of the Supreme Court's decision, first of all, for birthright citizenship, and then I will also talk about other injunctions that are already in place. So first of all, for birthright citizenship, then there's no change to the situation, which is that if you're born in the United States, then you are automatically a US citizen, and whether you're born of non-citizens or not. There are a few exceptions. If you're born of an invading army, which is not relevant today, if you're born of a diplomat, then you're a child of the diplomat's country, and if you're born in a ship at sea, in harbour in a ship. And it used to be there was an exception for the children of Native American Indians, but then with Indian Citizenship Act, then they also are automatically US citizens as well. So everyone, and this was established by a Chinese immigrant parents, and then they went back to China, and then their child wanted to return to the United States, and when he grew up. And the Supreme Court established that yes, because he was born in the United States, he could return and he's a citizen there. So it's a very clear case. And ever since then, and the law courts, they can't change this. So why has this become such a thing in the news then, when it's very, very clear what has happened? Well, what happened is that Trump did an executive order. And in this executive order, he said that no, birthright citizenship only applies to children of former slaves who are non-citizens. And anyone who is not a former slave, then their children is not a US citizen. And no lower court is ever going to accept that, and the Supreme Court is never going to accept that either. So they keep losing every single case against them. And so what happened is that all the Democrat governors in the entire United States, that's 22 of them, then they took out a case blocking Trump's unconstitutional executive order in their states. And that means that if you're in those, but they tried to do it universally. So this universal injunction, they got a justice to say, look, this is an unconstitutional order, so it shouldn't apply to anyone anywhere in the United States. And so they did this universal injunction, and that meant that it was blocked throughout the United States. But what happened is that Trump then took this to the Supreme Court, and he said to the Supreme Court, look, do not decide on whether my executive order is unconstitutional. Just decide on whether it was right for a justice to take out a universal injunction over the entire United States. So you need to know that the conservative justices in the United States, they are originalist and they are idealist. So they take things very literal in an abstract way. So because of their idealism, then not because Trump told them this, but because this is how justice is supposed to deal with cases, then if they're told to not peek at the underlying case, then they shouldn't do it, because that's just the way the law is set up. And the liberal justices, and they are realist, and they see the Constitution as a living thing that changes over the centuries, and they see laws as also as being like that they evolve and change. How they're interpreted is changed over the centuries. So the liberal justice said, look, that's nonsense. We have to look at the underlying case here, and it's a clearly unconstitutional order. And so the first thing they had to establish is the government harmed by this order being blocked? And liberal justice says, no, of course not. It's unconstitutional. You'll never be able to apply it in any state ever. So how can it be harmed by blocking an unconstitutional order? But the idealists, they said, well, look, the government has told us not to look at what it is that this injunction is about, so we can't decide whether it harms them or not. And so we have to assume it harms them. So that was the idealism, and why the originalist idealists went with the government's argument, not because they were just doing what Trump said, but because they are such really rather extremist idealists and extremely originalist. And then when it came to, well, what about universal injunctions? Now that the Conservatives have decided that the government is harmed, so the case can go ahead, then the Conservatives then said, well, look, the courts were set up in 1787 with the Judiciary Act. And so we have to look at whether there were universal injunctions back in 1787, decide whether universal injunctions are valid or not. And they looked back, they found something called the Peace Bill, and the Peace Bill of 1787 applied to a class of people, not to everyone universally. So they said, well, look, what we have today that is like that is a very rare procedure, but one will become very common now after this decision, and it's called an emergency certification of a putative class of people. So you can have a thing called a class injunction, which is an injunction that applies to all people that are similarly situated according to the law. And so in this case, it would apply to all the children of non-citizens. But you have to certify this class first, and this takes months, can take months and months to go through the legal process of certifying the class of all children of non-citizens. But there's an emergency certification, then you can't do it for the actual class because it hasn't been certified yet. But you can have a putative class, which is a class that you have strong reason to believe will be certified. And then you say an emergency certification of a putative class, and based on that, you can then have an injunction that applies to all children of non-citizens throughout the United States. So the Conservative justice said, look, we have this today, something today, which is very like a peace bill. It's almost identical to the peace bill of 1787, so this is what people should use. And they shouldn't use universal injunctions because there's nothing even remotely resembling that in 1787. And of course liberal justices, they see it as a living law, and they say, well, look, that's nonsense too, because we've had justices taking out universal injunctions for over a century. And so clearly the way that the Judiciary Act has evolved, that justices work has evolved and has changed as the society has changed and as expectations and understanding of the law has changed. So he said, look, we should accept universal injunctions because that's how it's been done for all this time. But the originalists said, but this has never been brought to the Supreme Court before, and we've never been asked to judge whether universal injunctions are valid or not. And now that we're asked to decide this, we have to go back to 1787, and it's very clear they're not. So that's why you got this decision, and I think it's quite important to understand that, because it is not a distinction between justices who are MAGA. They're not MAGA, they're not political in the way they decide. They do not decide. It would be extremely improper for a justice to decide based on how they vote and which president they vote for. And they often decide against Trump. So I hope this can help you understand that this is not to do with the Conservative justices. Rather, it is because the Republicans choose ultra-originalist and ultra-idealist justices because they tend to make decisions that Republicans like, because they, with their head in the clouds, I suppose it appears to liberal justices, idealist ideas, and stuck in how the laws, many of the laws that they need to decide on were decided centuries ago, and the way things were understood centuries ago often aligns more with Republicans than with Democrats. So that's how we end up in this situation. So that's the situation. So we do still have a solution. I don't think even the Conservative justices would have made a decision if there wasn't something that could be used to stop it nationwide. And for most things, the emergency certification of putative class will work pretty well. And even for birthright citizen, I think if you are a legal citizen in the United States, and not legal citizen, legal non-citizen. So if you're there on a visa, on a green card, if you are there as just as a permanent non-citizen resident of the United States, and you just don't want to apply for citizenship for one reason or another, then your child, you can still say, well, look, I'm a non-citizen. You're not going to deport me, so I can just go straight to the courts and just ask for and put my case. And so in all the yellow courts, there's no need for anyone to do anything. All the yellow states, then Trump's executive order is blocked, so you don't need to prove anything. But in any of the grey states, then before your child can get a social security number, for instance, and get the benefits of SNAP and Medicaid and things, then your child has to be established legally as being a US citizen, but not established because everyone, they have to prove to the Trump administration that they don't have to be children of slaves. That's what they have to do. So all through these grey states, before they can get a social security number or anything like that, they have to prove to the Trump administration that it's not necessary for them to be a child of slaves. And even though this is never ever going to be decided in favour of the government, they still have to keep on taking this out because of the absence of a universal injunction. But then once they have this emergency certification of putative class, which is going ahead right now, and probably it'll be in place in a day or two, then most people can use that. But the problem with undocumented citizens is that it might be that in the government, first of all, if they're criminal, of course, but also even if they're not, then the government has started deporting undocumented citizens, even if they're non-criminal, in many states. So if you happen to be in a grey state where the United States government is deporting undocumented citizens who are not criminal, and you're not criminal, and you have a child, and you want your child to be established as a US citizen, well, you'll have to go to the court. You have to say to the court, look, I'm an undocumented immigrant, and this is, and that's why I'm a non-citizen, and I want to establish that my child is a citizen. And then, as you leave the doors of the court, then you may be detained by the US government. You might even be deported. And even if you have established your child as a US citizen, then you would be asked, well, do you want to leave your US citizen behind while we deport you? Of course, they'll say no. So they have to go along with their new US citizen child to some foreign country. And and it might be that it takes a little while to get their child established as a US citizen, so they come out to the court doors and the child isn't even a US citizen yet. So, because we don't know yet how exactly it's going to be established, all this, and how exactly it's going to work. I don't know the details of how that process would work, as whether they're instantly a US citizen child. Probably legal professors have to go for them for that. So the simplest solution to all this, for people who don't know what they're going to do, what's going to happen, what if they're an undocumented immigrant. If you're an undocumented immigrant in South Carolina, then, but I'm not giving advice yet, because we've got 30 days for the organisations that help undocumented immigrants to work out what the best advice is. So go by whatever your organisation in your area says you should do. But just one possible solution might be, and really the simplest and safest way of doing it would just be to, if you're in South Carolina, and if you've got, say, relatives in North Carolina, and you're an expectant mother, well, travel to North Carolina and stay with your relatives and have your child there. And if you do that, and then wait there and then get your social security number in North Carolina, then if you do that, then you're ultra safe, because then it's a US citizen. And the way the citizenship amendment is written is that you're then a citizen for all of the United States. You're not just a citizen of North Carolina. So it's beyond incredible that if you go back to South Carolina, that the government will try to challenge your citizenship if you're born in North Carolina. Oh, and you won't need to prove it. You already have all the documents, so you'll be able to show your social security number and get SNAP and Medicaid and things, just because you got it in North Carolina. Whereas we don't know yet. It might be quite simple in South Carolina too, but we don't know yet. And it might be that if you're an undocumented immigrant, that it might be much more complicated. And we might even get, so hopefully this won't happen, but we might get the situation of undocumented immigrants with a citizen child, or should be citizen child, fleeing across the border into the yellow states to get away from ICE. So this was a scenario that was brought up in the oral arguments and in discussions of it. So, and the situation is that a situation like this has never arisen before, where the President has issued a completely unconstitutional order, and so it's very hard to, and especially with birthright citizenship too, so it's hard to know how this is going to turn out in the courts, and especially if the cases aren't challenged. So someone from South Carolina might travel into North Carolina, and they get their social security number, and they travel to South Carolina, they get their SNAP and they get their Medicaid, and none of this is ever challenged. So then it will never be established in the courts that is how to become a US citizen. But you will just be like a US citizen. You will be a US citizen because you've got citizenship in North Carolina. But nobody will even try to challenge it, so that's probably how it's going to happen. And then it might be that this, very probably a lot of people will use this putative, emergency certification of putative class. But in particular case of birthright citizenship, because of the issue of the government deporting undocumented citizens, they actually are in several states. They wait outside court cases. They look at the agenda of the court. They say, look, this is an undocumented citizen who has to go to the courts. They're being legal, law-abiding, undocumented citizen. And they say, well, look, we know they're going to be there on that particular day. We'll just wait outside the doors and we'll deport them. And that has been happening recently, very sadly, which is causing all sorts of problems for undocumented citizens, undocumented immigrants in some of the US states where this is going on. And the states can stop that, but especially if they have to go to federal courts. So New York, it's happening even in New York. But New York, of course, this whole thing is blocked in New York. So it tends to be happening an awful lot in the states that actually have Democrat governors. So I'm not sure quite how many people will be affected by this. But anyway, so I'm just talking about. So it's quite possible that none of this will happen, and that the government is just wanting to make sure it's trying to reduce the number of people on SNAP and Medicaid, and maybe that's all they're doing, and maybe they're not going to try deporting these undocumented immigrants. So you have to bear that in mind as well, and that may be all that it's about. And they're trying to reduce the number of people on SNAP and Medicaid by discouraging the undocumented immigrants from registering their child, trying to get their child established as a US citizen, and just confusing and muddying the waters. So it's possible that's all this is about. But there's some concern it might also be to do with ICE and deportation. So we'll see how it goes. But so anyway, if it does turn out to be about deportation and people, or if it does, either way, whether it's about deportation or whether it's about Medicaid and SNAP and things like that, then it's very likely there are going to be organisations in the yellow states that are going to provide travel funding. So if you are, say, in Alabama or something, or in Texas or whatever, you'd be you'd get someone who would, or Florida or whatever, then you would have if you're in Florida, you have quite a long way to go to the nearest yellow state. And if you're just here, you can just go across the border, and you might have quite expensive travel to get there. And so there are likely to be organisations that will, just as for the abortion laws and for LGBT laws, the variation between states, then you're likely to get organisations that will provide funding for you to travel to a yellow state, either to give birth there or immediately after birth, to then get your social security number there, and then to come back to your state, and then you can register there for SNAP and Medicaid and so on, because you've got your social security number for your newly born child. So that is the worst case, is that there'll be an awful lot of people travelling back and forth between the grey states and the yellow states, because they just don't want to take advantage, make use of this emergency certification, because they fear being deported. So that is the worst case that we have here. And it's highly unlikely that, well, we'll just have to see what happens. But hopefully the government doesn't try to deport parents of, that will be a big thing in the news if they do try to deport parents of newborns just because they're trying to establish their child is a US citizen in the courts. Anyway, so that's this very big complex situation. Hopefully I've explained it reasonably clearly, and I didn't find many people explaining this very clearly on TV quite yet, and so it will get sorted out in the next week. The Trump administration has got 30 days to work out what they're going to do about this, and what the rule is and how they're going to deal with this situation in grey states. And the CASA Inc., which is the one which took out this case, and all those 22 governors, they have 30 days to work out and to take out a class injunction for emergency certification of a putative class, and take out an injunction based on a putative class. So it's a putative class injunction. And so by 30 days from now, all this will be much clearer, and then people will be explaining that to you, and you can go to your local immigration. If you're an undocumented immigrant, then there'll be an organisation in your states, and they'll explain things to you. And so so I'm not explaining how the situation will be 30 days from now. I'm just explaining the situation as it is right now. And so I think I've explained almost all of it, actually. Is there anything else I need to explain now? So I might do a second video, explaining about the background and the way the justices are reasoned and so on, which I go into the rest of this blog post. But oh yes, and so the one thing I haven't explained yet is, what about the injunctions that are already in place? So for the injunctions that are already in place, then they stay in place for now. So they're not going to be instantly they're not going to instantly no longer work nationally. What's going to happen is that the government will challenge them, and then the justices will then be told that they have to change their injunction. So they then will restrict it to a narrow injunction, and at that point they very likely might take out more universal injunctions involving universities. They might convert some of them or add to them with emergency certification of a putative class in order to. So it's not necessarily going to mean that suddenly, for instance, all the people who've been prevented from being fired are suddenly going to be fired, because that injunction stays in place. It's not. This Supreme Court didn't instantly stop all those injunctions, and it gave a rather vague ruling saying something like it's likely that they would be stopped. So there's a bit of wiggle room, but it's highly unlikely that any other in principle, other universal injunctions could go back to the Supreme Court if the judge gave a very clear case for the universal injunction, and then the appeal court did, and then they appealed that again, and the Supreme Court decided to take on the case because the Supreme Court saw it as being interestingly different. But since this is such a very clear case for a clearly unconstitutional order, it's highly unlikely that any of the other universal injunctions will go all the way up to the Supreme Court. Probably the Supreme Court will just decline to hear all those cases. So that's how it's going to proceed in the future. It's not going to instantly mean that all these universal injunctions, the other universal injunctions, stop being valid. They remain valid for now, and then they have to be challenged. And then the courts, the district courts, will likely decide one by one that this national injunction can't be a national injunction anymore, and tell the judge to reframe it. The judge will then change it into whatever the closest approximation they have, and at that point they will start likely convert a lot of them into emergency certifications of putative classes, in addition to being injunctions for the original litigants. So all the ones that are for particular states, then they will remain as injunctions for those states. And so, and then they will try to extend them to other states using this emergency certification process. And for most cases, that will work. And so, for instance, there was one example that the Liberal justices gave was, what if a future Democrat president decides to, in an executive order, he just says, I'm going to take all guns from Americans, because that would be completely unconstitutional in the United States. But he just says that, just like Trump said, I'm going to take away birthright citizenship from all these people. Then what would happen then would be the same thing, emergency certification of putative class, of gun owners in this case. So it would be putative class of gun owners. There would be emergency certification saying that anyone who is a gun owner belongs to this class, and then there'd be an injunction for all gun owners that blocks this executive order by a future president who tries to take away their guns. So that's how that would work. And then that doesn't have the same problem that they would be deported for going to courts to proving that they're a gun owner. They just need to prove they're a gun owner, and then the injunction, the executive order no longer applies to them. So in most cases, this emergency certification of putative class will be very simple and straightforward, and it's just a slightly different way of doing things. And Alito, who doesn't like this at all, and he said, well, look, this is just going to come in the back in what did he say? Let's search for Alito. Let's search here for Alito. Read out what Alito said, which is for almost all injunctions. So let's go down to Alito. The universal injunction will return from the grave under the guise of nationwide class relief, and today's decision will be of little more than academic interest if class action suits are allowed to proliferate against Trump's executive order. So that's Alito, and that is surely what is going to happen. So for almost everything, then, and that's Alito himself, one of the Supreme Court justices, one of the ones who's most against universal injunctions, then by Alito himself, then he himself sees the universal injunctions as very likely as leading to something very similar to a class. The class injunctions, nationwide class injunctions, as being likely to work very similar to a universal injunction. He doesn't like that, of course, but most people, the people who are scared who I'm helping, then that's going to be, that helps you to say that, see, that actually a lot of these nationwide injunctions are just going to be turned into emergency certification of putative class that also applies nationwide, and so there'll probably be very little actually changed. The only thing that will be changed is this very messy situation for birthright citizenship for undocumented immigrants who are worried about being deported. So that's the main messy thing about this. And it's slightly more complicated, takes slightly longer than a universal injunction. But on the face of it, at least, we have to see how it works out. It doesn't look as if it's going to make a major difference, actually. It will help a little bit with judge shopping. It might slightly help with the way that with some of the problems that there were with universal injunctions. We'll just have to see how this happens. It might actually end up. Some people are saying that some people think that this might actually be better in the long run once we're used to it in some ways than universal injunctions. Well, just see it. So as you can see, it's not such a serious thing as some people make it out to be. Other people just make it out to be nothing at all when they're talking on the TV. And it's sort of in between the two, because it still has to be sorted out what what actually are the, because we've never had this very widespread use of emergency certification of putative class, it's very rarely used. It was used by the Supreme Court for the Venezuelan against the Alien Enemies Act, so it was used by them there. So that's an example that was actually used nationwide by the Supreme Court, so that shows it can be used. But up until now it was extremely rare for anyone to ever use it, and it's now going to be very commonly used, and so that's the main difference that's going to happen. And we it seems on this that it's likely to be not very much of a change, but we will find out as it becomes more and more widely used. So that's it. For contact details about our group, Doomsday Drunk and so on, see the end of this blog post, and I talk quite a lot about more details about this. So hopefully this helps, and if you've got any questions, do say, comment on this, anything like this. And if I've got anything wrong, even slightly a bit wrong, please do say any mistake I've made. I check this as carefully as I can, and I've read lots of blogs about it, and I looked up not what the legal professors are saying, but as I said, I'm not a lawyer. I'm just trying to distill a very complicated legal situation. My background is in philosophy and logic of the foundations of mathematics, and it turns out that this requires extremely clear ways of thinking, much clearer than for mathematics. A lot of people who do mathematics, the way they talk is not very precise. They know what they're doing, they understand, they know what a triangle is, they know what a line is, but they might have some difficulty to explain exactly what it is in fundamental notions of mathematics, and that was what I was involved in. Not just lines, and that's like Euclid's geometry, but things like numbers. What exactly is a number? What exactly? And I was particularly interested in infinity, and how infinity and whether it can be defined, what it means, and so on in mathematics. And so in very precise logical fashion. So this background combined with philosophy is what helps me to be able to parse legal cases and what the lawyers are saying about these legal cases very quickly and understand, because it's supposed to be something that the common person can understand, and it doesn't really work quite like that, but it is very straightforward and simple to me as a mathematician, logician, philosopher in background, combined with, of course, reading legal blogs. And I would never try to understand a legal case on my own, but based on reading the legal blogs and then going back to the case and then understanding what they're saying, and then that's how I'm able to get the structure of it in my mind. And then based on that, then I distill it into something much simpler, because I have an awful lot of experience with the Doomsday Drunk group, explaining things to people who are panicking and need a quick, simple, easy explanation as quickly as possible. And so that is where hopefully I can help here.